Ogundayomi Clement and Rubber Estates Nigeria Limited.
Yes, my lord. My lord, I mean, that matters.
Let's take appearances.
Okay.
Can you announce appearance, please?
Respectfully, my lord.
Yes.
I am A.O. Osemigi. My lord, I humbly appear for the defendant. My lord, Osemigi is spelled Osemwgie.
Thank you.
Defendant. Yes, my lord.
Who appears for the claimant?
My lord, it appears they are not online yet. My lord, they are not around, my lord.
The matter is for judgment.
Yes, my lord.
And this is the judgment of the court. The claimant took out a complaint against the defendant on 12 February 2021. The defendant filed a memorandum of appearance and statement of defense on 5th March 2021. The claimant prays for the following reliefs: a declaration that the termination of the claimant's employment with the defendant for no cause and reason, the claimant having meritoriously served the defendant for over 7 years without misconduct, is unjust, unlawful, unfair labor practice, and a violation of the defendant's employee handbook. A declaration that the termination of the claimant's employment with the defendant without recourse to the defendant's employee handbook is a breach of the contract of employment of the claimant, unlawful, unfair labor practice, and a violation of the defendant's employee handbook. C, a declaration that the defendant's query letter dated 4th day of November 2020 issued to the claimant is incompetent, invalid, and is a violation of the defendant's employee handbook. D, an order of this honorable court setting aside the defendant's purported termination of the claimant's employment via its letter of termination issued to the claimant dated the 9th day of December 2020, the termination having been tainted with bias, malice, unfair labor practice, and is a violation of defendant's handbook. E, an order of this honorable court directing the defendant to reinstate the claimant to his post in the defendant without any loss as to seniority, salaries, position, and other emoluments. An order of the honorable court directing the defendant to compute and pay to the claimant all his salaries, allowances, and other emoluments due to him, specifically from December 2020, when the employment of the claimant was terminated by the defendant up to the date of judgment, and or alternative to prayer E and F above, A, an order of this honorable court for the payment of the sum of 5 million naira as damages and compensation for loss of job, psychological and emotional trauma arising from the action of the defendant in unjustly and illegally terminating the employment of the claimant in the defendant. B, an order for the payment of the sum of 2 million naira as cost of this action. Case of the claimant. DJ Akindehin Esquire, you can mute your phone. You can mute your phone.
I got listening.
Thank you.
Thank you, my lord.
Thank you. It is the case of the claimant who testified as CW that I was since the 11th day of March 2013 an employee of the defendant as a tracking system operator unit leader, UL2, and my employment was confirmed in October 2013 by the confirmation of appointment letter dated the 3rd day of October 2013 by the defendant. I aver that from the period of the confirmation of my employment up until the 4th day of November 2020, when I was issued a query, I have never been found wanting in my task, duty, and schedule of my employment. I aver that the security coordinator, Mr. Ben Rachid, by a letter dated 4th day of November 2020, signed and stamped on the 5th day of November 2020, issued me a query. I aver that he promptly responded. He was again served another query on the 9th of November 2020, to which he responded that he received no further query or any correspondence, and he continued his work. NA58DH, you can mute your mic. It came to him as a surprise on the 9th day of December. He was issued with a letter terminating his employment. And the letter did not state, the letter stated that some sums meant for him have been paid into his account after certain deductions. If you are using NA58DH, please mute your mic. Thank you. Thank you. The claimant filed a reply to the statement of defense on the 30th March 2021. The reply is basically a denial of the statement of defense, which only joins issues with the statement of facts and a restatement with the statement of defense. Sorry. Okay. The reply is basically a denial of the statement of defense, which only joins issues with the statement of facts and a restatement of the facts, but of importance is paragraph 3 of the reply as covered by paragraph 5 of the deposition as follows. And this is what the witness says. I deny receiving any payment in lieu of notice, as the sums credited into my account were, to the best of my knowledge, not designated as such. Besides, I rejected the said sums via my solicitor's letter dated the 29th of December 2020 and demanded the defendant supply an account where same can be returned. The defendant did not reply to the said letter. The claimant tendered 11 documents which were admitted in evidence and marked as exhibits OP01 to OP011. Case of the defendant. It is the case of the defendant through DW, one Mr. Smart or Kioms. It is the policy of the defendant and which is provided in the employee handbook that an employee guilty of gross misconduct or breach of any of the company's rules and regulations or other terms and conditions of employment may be summarily dismissed in line with the disciplinary procedure of the company, and also that the defendant will terminate the employment of an employee upon payment in lieu of notice. On the 29th November 2020, the claimant and some other defendant employees inspected and received five truckload of cop homes from Utagba Uno site to Araromi factory, and all the truck recorded high shrinkage weight between 460 kg to 960 kg shortage, far above the accepted shrinkage level. It is his case that the claimant did not report until he was asked, and therefore he was queried, and he replied that subsequently the defendant terminated the claimant's employment and paid the claimant's salary in lieu of notice and termination benefits. The defendant complied with the disciplinary procedure that the they paid 3 months salary in lieu of notice, that the claimant failed to exhaust all the internal procedure for the resolution of dispute and failed to raise a grievance under the grievance procedure. The DW was also cross-examined. The defendant's counsel filed his final written address on 10th March 2023. Claimant counsel filed a final written address on 20th April 2023. He formulated 4 issues for determination. Reference shall be made to any part of the addresses as the need arises in the course of this judgment. Court's decision. A. Admissibility of Exhibit S01 tender. It is important to start with the admissibility of Exhibit S01 tender. The defense witness tendered in evidence the transfer slip for the payment of salary in lieu of notice and termination benefits, but the claimant's counsel objected on the grounds that it was not pleaded and it is not in an admissible form, being computer-generated document. The document was marked S01 tendered and ruling reserved till judgment. I find that this document was properly pleaded in paragraph 11 of the statement of defense, and that fact of the payment is not denied, as it is the case of the claimant in paragraph 12 of the statement of facts and paragraph 13 of the claimant's deposition, that the letter dated the 9th day of December 2020 also stated that some sums meant for me have been paid to my account after certain deductions. Furthermore, the fact of the payment is admitted in paragraph 3 of the reply to the statement of defense, and only the purpose of the payment is said not to be stated, being that the opposition is not to the fact of the payment, but because the document is not pleaded. The court has found it is pleaded and that it is not in an admissible form. I am of the firm view that it is in the interest of justice to invoke the provision of Section 12(2)(b) of the National Industrial Code Act 2006 and depart from the requirement of Section 84 of the Evidence Act and to admit the document in evidence. The objection is overruled and the document is admitted in evidence and marked as Exhibit S01. B. Merits of the case. I have read the pleadings and evidence, both oral and documentary, as well as the final written addresses of counsels, and I am of the view that the loan issue will determine this case, and the issue for determination is whether the claimant has established his entitlement to any of the relief sought. Both the claimant and defendant made it appear as if the claimant's employment was terminated as a punishment in relation to the query of the 29th of October 2020 with respect to the 5 truckload of cop lumps. The claimant, however, double speaks by also alleging that the letter of termination of my employment with the defendant dated the 9th day of December 2020 simply stated that my service is no longer required and did not give nor state any reason for the termination of my employment and made a heavy weight thereon. I have read Exhibit OPO7, the termination of appointment letter. It opens with, and I quote, "Your services are no longer required in the company." No any reason was adduced in any subsequent paragraph of the letter. Once the reason for termination is not stated in the letter of termination, no reason can be written into the termination letter by the employee, claimant, or defendant employer after the employee has sued in court. It does not matter that the reason existed in fact and that the termination was actuated by that reason. Once the matter is before the court, the place to look for the reason for termination is the termination letter. See Iwoha versus Mobile Producing Nigeria Unlimited, 2011 LPLR 4477CA at page 10, where the court held thus, and I quote, "Learned counsel for the respondent submitted that the lower court was right when it held that in considering the issue whether the termination of appointment of the appellant was right or wrong, the court must confine itself to the letter terminating the appointment and not go outside it to look for other reasons which the appellant thinks or suspects may have been behind the termination. This represents the correct position of the law. It is settled that where no other reason is stated for the termination of appellant appointment except that the appellant's services were no longer required, the court cannot go outside the said letter to discover the reasons for the termination. See Chukuma Shell Petroleum Development Company Limited. Chukuma versus Shell Petroleum Development Company Limited, 1993, for Nigeria Report, Part 289, page 512, CBN versus Amica, 2013, Nigeria Report, Part 683, page 21, and Cato versus CBN, quotation closed. From the content of the termination letter, which simply states that your services are no longer required in the companies, the claimant is not entitled to adduce any reason he suspects is behind his termination. See Cato versus CBN 1999, 6 Nigeria Will Report, Part 507, page 390 and 48, where the Supreme Court per Belgore JSC, as he then was, stated, the letter of termination of the respondent's appointment simply stated that his services were no longer needed, and he was advised to collect his 1 month's salary in lieu of notice as provided for in Clause 2 of Exhibit 7, Staff Manual. The Staff Manual, Exhibit 7, is the document regulating the contract of employment of the plaintiff with the defendant, and Clause 2 thereof is the binding clause. The letter of termination never adverted to any fraud, misconduct, or dishonesty, and the respondent cannot read into his termination letter what is not contained therein. It is also clear that the argument of the defendants that the termination was for misconduct does not flow from the content of the termination letter, but from what the defendants' counsel thinks or imagine could have been the reason. This is not permissible by law. CEO and Mobile Producing Unlimited, already cited. Where an employee is dismissed from office and the termination or dismissal letter did not cite a reason for the dismissal or termination, it means the employee was dismissed or terminated for no reason, and it is not available for the defendant employer to adduce reasons for the dismissal or termination after the employee has challenged his termination or dismissal in court. The duty of the defendant when sued is to justify his action based on the reasons stated in the letter of dismissal, not to put up a reason hitherto not stated into the letter, even if the reason existed in fact. C. Jimo Gabriel Yemi versus Executive Governor Kwara State and two others. Suit number NICN/IL/11/2019 unreported a judgment of this court delivered on 29th day of September 2020. 2. Samuel O. Bamisaye and the governor of Kwara State and two others. Suit number NICL/IL/14/2019 unreported a judgment of this court delivered on 22nd of March 2021. 3. Adegboye Oyebanji versus UBA. Suit number I find, therefore, that the claimant's employment was terminated for no other reason than that his services were no longer required. The next and pertinent question. The next and pertinent question is whether the termination was in line with the terms of contract or contrary to the terms of contract and actuated by malice as contended by the claimant. We must remind ourselves that the relationship between the parties herein was that of master-servant. In a master-servant employment relationship, termination is regulated by the letter of employment and the staff handbook, which both parties must strictly adhere to. See Abalogu versus SPDCN Limited 2017 10 SCELR page 1, page 62 and 83, paragraph 10. On the procedure for termination of employment, the employment letter exhibit OPO2 and the employee handbook exhibit OPO3 are relevant here. According to the employment letter exhibit OPO2, paragraph 5 states as follows. A 1 month notice will be required by either party to terminate this appointment after confirmation, while other conditions in our condition of service will be applicable to you. According to the employee handbook exhibit OPO8, under resignation/termination of employment at page 28, it is provided as follows. The company or employees can terminate the employment contract without assigning any reason whatsoever by given notice. Where employment is to be terminated without notice, there shall be payment in lieu as contained in the employment contract. By the pleadings and evidence before the court, the defendants have complied with the procedure for termination of the claimant's employment as far as the letter of employment and the staff handbook are concerned, and the ground of reinstatement or damages does not arise in this case. Furthermore, it's not the contention of the claimant that he would have been entitled to more than the sum paid to him by the defendant had it followed the staff handbook. On reinstatement, it is the submission of the claimant counsel in paragraph 18 at pages 10 and 11 of his final written address as follows, and I quote, while common law principles seems to resist reinstatement in master-servant relationship, our courts have ordered reinstatement when it is shown that the termination of the servant's employment was done as a victim of trade union activities, when the law does not support the circumstances and procedure the employee's services was terminated, and when the employment enjoys statutory flavor. And he quoted some judgments of the Court of Appeal, some judgments of the NIC there. As correct as this position of the law may be rightly stated, that situation does not arise in this case, as the contract of employment was terminated in line with the terms of contract. On the whole, the case of the claimant fails and is dismissed for want of merit, each party to bear its cost. This is the judgment of the court, and it is accordingly entered.
Have the court, please.
Last call, please.
My
Thank
Lord,
you.
we are very grateful to my
Has
Lord
the
for.
claimant counsel appeared?
Yes, my lord, we are here. The claimant's counsel is here.
Okay, announce appearance.
With profound respect to the Honorable Court, my name
Yes.
is Deji Fashusi.
Deji who?
Fashusi. Fashusi is F-A-S-U-S-I. F-A-S-U-S-I for the claimant.
Yes,
I
what
apologize,
did
my
you
lord.
say?
My lord, F-A-S-U-S-I.
What did you say to the judgment?
Oh, well, my lord, first I want to apologize. We were not online immediately. My lord was about to deliver the judgment. It was network issues. We want to thank my lord, regardless of the position that the court has taken. We thank my lord. We are very grateful, notwithstanding.
Osemige, my Lord. My Lord, yes, my Lord. My Lord, on our part, we are very grateful to my Lord for the well-considered judgment. We want to thank my Lord for the industry and the time put in the judgment. We are grateful, my Lord.
Thank you. The judgment is ready for collection today.
Oh, very well,
as
my
the
lord.
we are very grateful, sir.
Thank you.
Thank you, my Lord.
The next judgment. AK 24-21, Mr. Timothy Olufemi and UBA. Thank you. Excuse. Mr. Timothy Olufemi and UBA. AK 24-2021. Any appearance?
My Lord. Yes, my Lord.
Please announce your appearance.
With utmost respect to this honorable court,
Yes.
I am Fortune Falade. My humble appearance is for the claimant. Fortune.
Fortune Falade.
Yes, my Lord.
You are for the claimant.
Yes, my Lord.
Yes, who appears for the defendant?
My Lord, it appears they are not here, maybe due to circumstances that are beyond their control.
Okay, let's see if by the end they would have appeared.
Yes, my Lord.
This is the judgment of the court. By a complaint taken out by the claimant on 24th February 2021 and amended by a motion of 16 May 2022, the claimant seeks for 4 reliefs and 1 in the alternative as follows. A, A declaration that the forced resignation of appointment of the claimant on 17 July 2020 through handwritten letter dictated, instructed, and directed by the area operations manager of the defendant, acting under the directive of the defendant management under duress upon the ground of behaving discourteously to one road user, a long distance there is constitute a blatant and flagrant violation of the claimant's right as enshrined in section 34(1), 36(4), and 6 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the African Charter on Human and People's Rights Ratification and Enforcement Act, Cap A9, laws of the Federation of Nigeria, and therefore illegal, wrong, unlawful, null and void, and of no effect whatsoever. B, a declaration that the forced resignation of the appointment and subsequently the exit from bank letter dated July 20, 2020, which prematurely disengaged the service of the claimant from the employment of the defendant, was a gross violation of defendant's group staff handbook, the defendant's policy document on disengagement of the defendant's employee from the bank, particularly section 9 of the document, and therefore wrongful, unlawful, null, and void. C, an order of this honorable court reinstating the claimant as an employee of the defendant, with all his entitlements, including his salary arrears since July 2020 till date, and other allowances agreeable to the claimant from the defendant forthwith. An order of this honorable court directing the defendant to pay to the claimant the sum of 50 million naira only as general damages. Alternatively, in the alternative to granting the claimant's relief sought in paragraph 17(a)(d), the claimant pray for an order of this honorable court directing the defendant to pay all the salary arrears of the claimant from the date he was unlawfully disengaged from the services of the defendant on 17 July 2020 until the date of judgment in this case at his appropriate salary scale from the unlawful and wrongful termination of the employment of the claimant, and for such other orders as the court may deem fit. The defendant filed a memorandum of appearance on 22nd April 2021 and a statement of defense on 15th June 2021, and the claimant filed a reply on 12 July 2021. Case of the claimant. Testifying as PW, it is the case of the claimant that he was employed as assistant banking officer by the defendant on August 4, 2006. On 15 July 2020, he received a query from the bank manager, Relief, Mr. Goodluck of BD, wherein he complained of the road user through his Twitter was attached. It was therefore a rude shock to me to have been forced under duress to write a resignation letter at about 8 p.m. on 17 July 2020 by Mr. Martins Farabi, the area operations manager at Alagbaka Akure branch of the defendant, claiming to be acting on instruction of the management. The particulars of my forced resignation are as below, and this is about afternoon on the 17th July 2020. Mr. Martins Farabi, the area operation manager, called me to tell me to wait till after the close of work of the day for a chat. When it was about 7:30 p.m. on that day of 17 July 2020, when all staff had closed, I called Mr. Farabi if I could come for the chat, but he told me to wait for a few more minutes. When it was exactly 8 p.m., 17th July 2020, When the branch was left with only the security staff, Mr. Farabi called me to his office and asked me to resign my appointment on the directive of the management from Lagos. When I probed him for the reason, he said the management claimed they read in the internet service that I was rude to a customer of the bank over issues involving rough driving of the bullion drivers of the bank. When I tried to explain my own side of the story, that the person involved was not even a customer of the bank, but a road user who was trying to obstruct the movement of the bullion vehicle, but was not in any way affected, whether through damage to his vehicle or personal injury, and was already handling the issue with the driver's unit of the bank. He refused to be persuaded, insisted on the resignation, claiming he has no power to reverse the management decision. I then asked Mr. Farabi to put it into writing or allow me to talk to the officer that gave him the directive. He refused and suddenly became wild and instructed the security staff to close the gate against me until I comply with the writing of the resignation letter. Therefore, in order to avoid creating any ugly scene in the bank with Mr. Farabi, I decided to comply by handwriting the resignation letter dated 17 July 2020. That as early as possible on the following day of July 18, 2020, I sent a Yahoo Mail message on Android to the Group Managing Director, GMD, Mr. Kenneth Uzoka, to explain the scenario between me and Mr. Farabi on the forced resignation of my appointment and plead with him to use his good office to intervene in the matter to reserve my appointment with the defendant. That instead of positive response to my Yahoo Mail appeal, I was rather surprised to see the defendant's letter dated 20th July titled to exit from the bank, indicating an acceptance of the said forced resignation of appointment. That despite all efforts made by me to make defendant rescind or change their decision to arbitrarily discharge me from their service, the defendant bluntly refused. That the forced resignation of my appointment is contrary to labor law and even the defendant group staff handbook that governs the rule of relationship between management and his staff in general, which is already pleaded. Testifying in reply to the statement of defense, PW stated that I was never informed in any way of my reposting to head of cash officers' decks, and Mr. Martins Farabi could not have validly done so as he lacked the capacity to do so in line with the provision of the defendant's group handbook. That I verily know that Mr. Anthony Ado was not present at all at the bank premises during the July 20, 2020 encounters. He was not also the defendant's branch manager at Alagbaka branch at this material time. He was the marketing relationship officer of the bank, hence his deposition on the subject matter of this case is a complete falsehood. That no other staff members were around or present as at the time I had encounter with Mr. Martins Farabi at about 8 p.m. on the 17th July 2020. That hence the formulated story of my resignation and permission from resignation and persuasion from resignation never happened and merely fabricated as the defense for this case. Case of the defendants. It is the case of the defendant through DW Martins Farabi that the claimant voluntarily and willingly resigned his appointment with the defendant on July 17, 2020. That on July 14, 2020, a man referred to claimant came to complain about the bullion van escort, and the claimant shirked his responsibility by rudely referring the complainant to the head of the bullion van drivers. That neither the defendant nor I had any cause for the He forced the claimant to resign as there are appropriate and lawful methods of sorting out any issue the defendant may have with any of her employees, including the claimant. Being the area operation manager, I had no cause to tell the claimant to wait till after close of work, and the claimant was obliged by his position to stay in the office till close of work. That on July 17, 2020, between 6:30 p.m. and 7 p.m., I invited the claimant to my office to inform him that with effect from July 18, 2020, claimant would no longer retain his position as customer service manager, but was posted to head the cash officer's desk with all his emoluments unaffected. That the purpose of the posting was for monitoring and retraining of the claimant for efficient and effective service delivery. That the claimant was incensed and arrogantly vowed that rather than accepting such posting, he would resign. Claimant then walked out of my office. That while claimant left my office, claimant informed Mr. Anthony Ado, the defendant's Alagbaka branch manager, and some of the other staff who were still around that he was done with the defendant and was going to tender his resignation letter. That Mr. Anthony Ado and some of the staff members gathered around the claimant and tried to persuade the claimant from resigning, but to accept his new posting. That the claimant returned about 25 minutes later with a letter of resignation, which he dropped on my table. That even after dropping the letter of resignation on my table, I was joined by Mr. Anthony Ado, and both of us tried to talk claimant out of resigning, but claimant refused. That during the interaction between me and the claimant, which took place between 6:30 p.m. and 7 p.m., some of the defendant staff, including Mr. Anthony, were still in the office, and there was no reason whatsoever for me to request the claimant to resign his appointment with the defendant or to instruct the security staff to close the gate against the claimant. That the defendant, in her effort at maintaining a cordial relationship with the claimant, even paid the claimant more than claimant was entitled to. That Mr. Kennedy Uzoka, defendant's group managing director, did not receive the alleged email from the claimant, and that even if he did receive the said email, which is denied, he was not obliged to accede to claimant's request, particularly when he was privileged to also call for explanation from me, who claimant accused of forcing him to resign. DW2 was one Ogunbade Jayeola, head of security. He testified that I was in charge of the entrances and gates to the Alagbaka branch, that the claimant was the customer service manager at Sorry, gentlemen, for the interruption in transmission.
Welcome, Benin.
Thank you. Okay, I was on paragraph 27 on the testimony of DW2, that when the complainant was subsequently going out and he was complaining bitterly about the encounter with the claimant, he was threatening to put his experience on the social media, notwithstanding my appeals to him. That throughout the day of July 20th, 2020, particularly around closing hours, nobody, including Mr. Martins Farabi, instructed me or any security staff under me to lock the gate against anyone or the claimant. Both counsels submitted their final written addresses, and reference shall be made to any part of a written address as the need arises in the course of this judgment. Court's decision. In civil cases, matters are determined on a preponderance of evidence. The burden of proof lies first on the claimant before it will shift to the defendant to rebut. See Omos Shebi and others versus Bakari and others LPLR 59623 CA, where the Court of Appeal for Loculo Sojipeje CA held as follows. I would want to reiterate the position of the law to the effect that the onus of proof in a civil matter lies on the plaintiff to establish his case upon a preponderance of evidence to the satisfaction of the trial court entertaining the case. In this regard, see the case of Okoye and Wanko 2014 LPLR 23172 SC, where the Supreme Court dwelling on the meaning of burden of proof rules governing burden of proof in civil cases, stated thus: a burden of proof in civil cases has two distinct meanings, namely one, the first is the burden of proof as a matter of law, and the pleadings usually referred to as legal burden or the burden of establishing a case. B, the second is the burden of proof in the sense of adducing evidence, usually described as evidential burden. While the legal burden of proof is always stable or static, burden of proof in the second sense, i.e. evidential burden of proof, may oscillate constantly according as the source of evidence or the other ponderates. In this case, the first resignation was alleged to be carried out by one Mr. Martins Farabi, DW1. The main allegation relevant to the case of the claimant, which is a case of forced resignation / constructive dismissal, is in paragraph 10 of the claimant's depositions and paragraph 11 of his deposition in reply, while that of the defense are as in the summarized deposition of DW1, Mr. Martins Farabi, against whom the allegations were made. It is a consideration of these depositions that will tilt the balance of probability one way or the other. Paragraph 10 of the claimant's witness deposition is hereby reproduced as follows. Paragraph 10. That the particulars of my first resignation are as stated below. I'm quoting. A. About afternoon on the 17th July 2020, Mr. Martins Farabi, the operation manager, called me to tell me to wait till after close of work of the day for a chat. When it was about 7:30 on that day of 17th July 2020, when all staff had closed, I called Mr. Farabi if I could come for the chat, but he told me to wait for a few more minutes. When it was exactly 8 p.m., when the branch was left with only the security staff, Mr. Farabi called me to his office and asked me to resign my appointment on the directive of the management from Lagos. When I probed him for the reason, he said the management claimed they read in the internet service that I was rude to a customer of the bank over issues involving rough driving of the bullion drivers of the bank. When I tried to explain my own side of the story, that the person involved was not even a customer of the bank, but a road user who was trying to obstruct the movement of the bullion vehicle, but was not in any way affected, whether through damage to his vehicle or personal injury, and was already handling the issue with the driver's unit of the bank. He refused to be persuaded. He insisted on the resignation, claiming he has no power to reverse the management decision. I then asked Mr. Farabi to put it into writing or allow me to talk to the officer that gave him the directive. He refused and suddenly became wild and instructed the security staff to close the gate against me until I comply with the writing of the resignation letter. Therefore, in order to avoid creating any ugly scene in the bank with Mr. Farabi, I decided to comply by handwriting the resignation letter dated 17 July 2020. The relevant positions of DW1 in paragraph 18, 20 to 25, and DW2 in paragraph 11 in rebuttal I hereby reproduce. The DW1 testified that on 17/20/20, between 6:30 p.m. and 7 p.m., I invited the claimant to my office to inform him that with effect from July 18, 2020, claimant would no longer retain his position as customer service manager, but was posted to the cash officer's case. 20. That the claimant was... Please, 23053. Mute your mic. Mute your mic, please. Can you please mute your mic? Mute your mic. Thank you. That the claimant was incensed and arrogantly vowed that rather than accepting such posting, he would resign. Claimant then walked out of my office. While claimant left my office, claimant informed Mr. Anthony Adu, the defendant's Alagbaka branch manager, and some of the other staff who were still around that he was done with the defendant and was going to tender his resignation letter. 23. That Mr. Anthony Adu and some of the staff members gathered around the claimant and tried to persuade the claimant from resigning, but to accept his new posting. That the claimant returned about 5 minutes later with a letter of resignation, which he dropped on my table. That even after dropping the letter of resignation on my table, I was joined by Mr. Anthony Ado, and both of us tried to talk claimant out of resigning, but claimant refused. That during the interaction between me and the claimant, which took place between 6:30 and 7 p.m., some of the defendant staff, including Mr. Anthony Adu, were still in the office, and there was no reason whatsoever for me to request the claimant to resign his appointment with the defendant or to instruct the security staff to close the gate against the claimant. TW2 testified in paragraph 11 as follows: that throughout the day of July 20th, 2020, particularly around closing hours, nobody, including Mr. Martin Farabi, instructed me or any security staff under me to lock the gate against any of the claimant. In his reply, the claimant testified as follows, paragraph 11, K and L. I was never informed in any way of my reposting to the head of cash officer's desk, and Mr. Martin Farabi could not have validly done so as he lacked capacity to do so in line with the provision of the Defendants Group Handbook. That I verily know that Mr. Anthony Adu was not present at all at the bank premises during the July 17th, 2020 encounters. He was not also the defendant's branch manager at Alagbaka branch at this material time. He was the marketing relationship officer of the bank. Hence, his deposition on the subject matter of this case is a complete falsehood. M, that no other staff members were around or present as at the time I had encounter with Mr. Martins Farabi at about 8 p.m. on July 17, 2020. N, that hence the fabricated story of my resignation and persuasion from resignation never happened and merely fabricated as a defense to this case. From the above state of evidence, the duty of the court is to use the legal scale to determine on whose side the scale tilts. A, While both the claimant and Mr. Farabi are agreed that the event took place on the 17th July 2020 in Mr. Farabi's office at the close of work, the claimant said Mr. Farabi called me to his office and asked me to resign my appointment on the directive of the management from Lagos. Mr. Farabi said, I invited the claimant to my office to inform him that with effect from July 18, 2020, the claimant would no longer retain his position as customer service manager, but was posted to head the cash officer's desk with all his emoluments unaffected. The pertinent question is whether the posting was not an official act that needed a written letter to that effect, and why must it wait till close of work? There is no evidence of the posting of the claimant from customer service manager to cash officer's desk. The parole evidence is not sufficient to prove that for the parole evidence of DW1 is not sufficient to prove that fact. B, the claimant said it was exactly 8 p.m. on that 17 July 2020 when the branch was left with only the security staff, but DW1 said Mr. Anthony Adu and some of the staff members were present and even tried to persuade the claimant to no avail. Surprisingly, neither Mr. Anthony Adu nor any of those staff testified. Even when the claimant repeated this assertion in his reply and expressly stated that Mr. Anthony Adu was not present at all at the bank premises during the July 17, 2020 encounters, hence his deposition. On the subject matter of this case is a complete falsehood. They said Mr. Anthony Adu was not called in spite of making a witness deposition. The claimant said Mr. Farabi, the claimant said Mr. Farabi instructed the security staff to close the gate against me until I comply with the writing of the resignation letter. Mr. Farabi denied this, and DW2, the head security, was the head of security, was called to rebut this, but this is his testimony. He said that throughout the day of 20th of July 2020, particularly around closing hours, nobody, including Mr. Martins Farabi, instructed me or any security staff under me to lock the gate against anyone or the claimant. This denial of an instruction to lock the gate on 20th July 2020 fails to rebut the allegation of locking the gate on 17th July 2020. On the legal scale of probability, therefore, I believe the claimant that one, on the 17th July 2020, Mr. Farabi called the claimant to his office after work and asked him to resign his appointment on the directive of the management from Lagos. 2, that the claimant was not posted to the cash officer's desk. 3, that there was no one else except Mr. Farabi, the claimant, and the securities. 4, that Mr. Farabi instructed the security staff to close the gate against the claimant until he complied with the writing of the resignation letter. What is more, according to the claimant, he immediately, on 18 July 2020, sent a Yahoo Mail message on Android to the group managing director, GMD, Mr. Kenneth Uzoka, to explain the scenario between him and Mr. Farabi on the forced resignation of his appointment and plead with him to use his good office to intervene in the matter to preserve his appointment with the defendant. The denial of this fact does not belong to the DW1 as done in this case, and particularly this assertion is backed by evidence, that is Exhibit GOA5. I accordingly believe the claimant. also worth noting that the content of the resignation letter does not portray a premeditated action on the part of the claimant. The resignation letter Exhibit DOA 2 is a one-sentence letter which reads as follows: I wish to use this medium to resign my appointment with the bank. I accordingly find that the claimant was forced to resign his employment with the defendant under circumstances that amount to constructive dismissal. On the whole, the case of the claimant succeeds. For the avoidance of doubt, it is hereby declared and ordered as follows. The declaration that the forced resignation of appointment of the claimant on 17 July 2020 through handwritten letter as instructed and directed by the area operation manager of the bank, Mr. Martins Farabi, amounted to forced or constructive dismissal. B, the defendant is hereby ordered to pay to the claimant a sum of 30 million naira only as general damages for the forced or constructive dismissal. C, the defendant is hereby ordered to pay the claimant cost of 200,000 naira. D, the judgment sum cost as 3,200,000 naira is to be paid within 30 days of this judgment, or the sum shall attract 10% interest per annum. This is the judgment of the court, and it is entered accordingly.
As call, please.
My lord.
Yes. Defense counsel, has the defense counsel appeared?
Yes, my lord. My lord, I seek the indulgence of court to announce my appearance for the defendant.
Please do.
KT Duru is my name.
Say?
Humbly, my lord. KT Duru is my name.
It's okay.
The name again, please.
KT Duru, my lord. My lord, Duru is spelled as D-U-R-U. My humble appearance is for the defendant. I am most grateful, my lord.
This matter, or are you holding somebody's brief?
Yes, my lord, from the office of Chief Olajide Ajanese.
Okay.
Yes, my lord.
You say your name is KT Duru.
KT Duru, my lord. Yes, my lord. I thank my lord for the indulgence.
Yes, Falade.
Yes, my lord.
Yes, Duru. Okay, you say you thank the court.
Yes, great.
Falade, what do you say?
My lord, all we have to say is that we have to accord my lord a hefty appreciation for this well-considered judgment. We are most grateful, my lord.
Thank you. The judgment is ready for collection today.
All right, now thank you, my lord. As the court pleases.
Is anyone here for any other judgment? Yes, my friend. Say what? Finger Island is for 29th. Yes, check the proceedings, please. Okay. All right. Not even in 5. All right. You say this Shola Ola Dimeji is born 28, right? Remaining only those two. NIC AK 23 2020. Yes. Mrs. Adenike Modupe Fadipe and College of Health Sciences and Technology, Ijero, Ekiti. AK 23 2020. Is anyone here for that matter? Even if This matter was filed on 13 July 2020. It was first mentioned on 5th October 2021. There is no proof of service in the file of the original process. Both counsel and claimant have gone to sleep on the case. This case is accordingly hereby struck out. In case 2022, Incorporated Trustees of Nigeria Union of Tailors and 3 others versus Incorporated Trustees of Tailors Association of Nigeria and 4 others. Okay, appearances.
Upon respect to my noble lords,
Yes.
Abiodun Fashakin is appearing for the claimants.
There's 2 appears for the defendants.
With a great respect to my noble lord.
Yes.
My lord, my name is DJ Akinde.
JJ.
DJ, my lord, D for Daniel, J for Jesus. Akinde. Well, our apparent is for the defendants, all the defendants.
Not all. First to first.
Defendants, applicants, my lord.
Last time you appeared for first to fourth.
Yes, my lord, first to fourth. All the defendants, my lord.
Not all.
It's not all now.
There is a fifth.
I'm sorry. I'm sorry, my lord. First to fourth defendants. I'm sorry, my lord.
Yes.
First to fourth defendants. I'm sorry, my lord.
Yes. Who is appearing for the 5th defendant? Ever Ayegusi appeared for the 5th defendant at the last time.
Yes, my lord. He was. I saw him was online.
Yes,
Ayegusi is online. He's still online.
Ayegusi.
Ayegusi.
Respectfully, my lord.
Yes.
Okay. I'm F.O. Ayegusi.
Yes.
My lord, Assistant Director, Legal Drafting and Law Review, my lord. Ondo State Minister of Justice, my lord. My humble appearance, my lord, is for the 5th defendant, sir. My lord, I'm sorry. I hope my lord can hear me very well, sir.
Sure, I did.
Oh, grateful, my lord.
Yes. Yes.
My lord, we have a pending application, my lord.
That's first, second.
First to fourth.
My lord, yeah. Okay. My lord, the claimants are also having a pending application.
Okay.
Yes.
The claimant, let me. Your application is for what?
My lord, application is for extension of time. We wish to file our counter affidavit and a demi order. My lord, is dated 13th February 2023 and 5 September.
You want me to write it?
Sir?
Do you want me to write what you are saying?
My lord, yes, my lord, we have a pending application, my lord. The first to fourth defendant applicant.
Yes, yes.
We have a pending application, my lord. It's
for
dated
extension of time to file what?
to file, within which the first to four defendants can file their counter affidavit to the claimants.
Counter affidavit to what?
To the claimants originating summons in this suit.
Yes, claimant.
My lord,
have you been served? Have you been served?
We have been served, my lord.
Are you opposing?
We are not opposing the application.
So, can you move in terms?
More good for my lord. But I will humbly move in terms of the motion paper. I will urge your lordship to grant the application as prayed.
No objection.
Yes, my lord.
Court, application granted as prayed. Yes.
Humbly, my lord, sir.
Yes.
Humbly, sir. My lord, the few defendant is represented, my lord.
Ayegusi.
Yes, my lord.
Do you have a motion?
No, I don't have any, my lord. I'm only saying that the few defendant is represented, my lord.
Okay, sorry.
Yes, my lord.
Okay, I didn't ask whether or not you objected. I'm sorry about that.
Most obliged, my lord.
All right. But Pasakin,
yeah, my lord,
have a motion.
We have a motion too, my lord, to regularize our further affidavit to the counter affidavit, the respective counter affidavits.
To file our further affidavit.
Yes, sir. That is dated 14th March 2023 and filed on 15th March. And the application was duly served on the defendant's counsel.
Akinde, have you been served?
Hello, we have been served.
Ayegusi, have you been served?
Very well, my lord, will be well served, sir.
Is anybody objecting?
Hello, we are not objecting.
No, my lord, not at all, my lord.
So you move in terms.
Consequently, my lord, we only move in terms of our motion paper. And we urge your lordship to grant our application as prayed.
Application granted as prayed.
As copied.
As popular places.
What next?
My lord, subject to the convenience of your lordship, the matter is ripe for hearing, sir. Okay. And we are ready on our part.
Okay. Unfortunately, we are soon closing down. I don't want to have the judgment on my head during the Christmas break. So I will, since all the things are in, I will do what I can do, if I can, for the adoption. But we'll take an early date in January 2024 for adoption. Okay. Adjourned to 17 January 2024 for hearing.
As places.
My lord, I'm sorry, sir. My lord, I'm most awfully sorry, sir. I didn't get the date, sir.
17th January.
My lord, I'm sorry for 17th of January, sir. I am before your learned brother, my lord, at the High Court of Ondo State, sir. 17th precisely, my lord. I'm indeed sorry, sir.
Can we come on the 18th?
My lord, I'm before your learned brother at the High Court, Ado Ekiti. It's on the 18th.
25th
Someone please suggest
January.
25th. 25th, my lord.
Yes.
Okay, 25th. It's convenient to us. 25. 25.
As
Go to 25th January 2024 for hearing.
Ask call, please.
Let's go,
Very
please.
grateful, my lord.
Most grateful, my lord.
Most grateful, sir.
Yeah, another matter. Many one. ILO 8 2022 between Nigeria Social Insurance Trust Fund Management Board and Al-Hikmah University, Ilorin.
Yes, my lord.
With different okay. Okay. Appearances.
Yes, my lord. My name is A.E. Alfanla.
Please spell
A-L-F-A. A-L-F-A.
Okay. I've seen it.
Dash N. Thank you, my lord. My humble appearance is for the claimant, sir.
All right. Who appears for the defendant?
Actually, none, sir. And the reason is that the last sitting, the case was adjourned for the hearing / report of settlement.
Okay.
Unfortunately, the report, the settlement will not be able to exist, sir, due to the nonchalance of the defendants, my lord. And when the matter was later adjourned,
so what do you want?
My lord?
What do you want?
Actually, having been served, we want, actually, the matter slated for the hearing. Unfortunately, I don't know what the court is. The court is maybe at the discretion to determine exactly what. Actually, we are ready for the hearing, but my sole witness is not with me right here, my judge.
So how are you ready? I will put you on record.
Okay, I'll stop
we are ready for the hearing, but my sole witness is not here. All right, the court is ready for the hearing.
I'm very sorry, my lord.
Yeah.
Due to this fact that my witness is not present, I would like to ask for another date for hearing, sir.
Please, you will ensure service on the defendant, physical service.
Okay, my lord.
Did they enter appearance?
Okay, my lord. They did not, sir.
So you will ensure physical service.
No problem.
This case is adjourned to 30th January 2024 for hearing. Defendant to be served physically.
As court pleases. Thank you, my lord.
Well, that is all for today, and we shall all leave.
As court pleases.